You said more likely than not, correct?
Yes.
So you cannot be entirely sure.
I mean, within the field of science, there's never 100% certainty.
Is there a known error rate for diagnoses of PTSD?
That's a great question.
Very good question.
What I really learned is the way a lawyer approaches a case and the professionalism required and the time required beforehand, before you ever get into the courtroom. That's what I learned the most this week.
We really see this as a model for the future of legal education because it really is a unique and really exciting partnership between lawyers, judges, and academics in training the next generation of lawyers in a way that law schools have not done in the past. Our students are being trained by the top lawyers in the country who come in to participate in this program. And then the students have an opportunity at the end of the program to argue in front of a real federal judge sitting in his own courtroom or a top-level senior state judge. And it brings that kind of training, the kind of sophisticated training that you might not get until you're a second or third year associate at a top firm. And it brings that into the law school experience so that you're getting that kind of training and you understand what an interrogatory is. You understand what due diligence really means. You understand the way to interact with a client. That's the kind of stuff law schools have not traditionally done a good job teaching students. And this program is really filling that gap.
You will be in a room with a student who is prepared to play the expert of either the plaintiff or the defense. You have an hour for prep this morning. At 10:30, we will then reassign you to rooms, and you will be in a room with a plaintiff attorney and a defense attorney, and the students will take the deposition this morning of the plaintiff attorney.
The civil litigation track is focused on pretrial litigation. And this is crucially important because the reality is in the modern world of law practice that courts are hearing fewer and fewer trials. So matters are now being resolved overwhelmingly before they get to an actual trial. So that's where the real work of lawyering goes on for most lawyers.
The #1 game plan for any expert's deposition is walking out of there with all of their opinions. This is very easily done. First, Dr. Gage, you wrote a report in this case. Yes? Yes. Does that report contain all of the opinions which you intend to express at trial? Yes. Do you
Or
understand?
usually, most of them as of this date.
Yeah,
That's what
or
they'll
it
say.
depends.
So our client's big concern is after this transaction, Iberia will just be money in a bank and no longer a company.
The business transaction program is also filling a huge gap in most law school curriculums.
Shell, there's going to be nothing there. So if there are liabilities from these civil suits that are coming over to us, we need...
What you rarely get in the past is exposure to what business lawyers do in working with each other to put together a deal, in making a deal happen, and this program simulates that all the way through.
I believe that the boot camp is an important differentiator for marketing to many of the law firms that recruit from Tulane. I think it's a very important first step, and I think it's very valuable, and from what I understand, the feedback has been tremendous, and the students appreciate it, and so it's definitely something that I'm really proud to be involved in, because I think it really is starting to be a part of the change that I think that's very important for the whole profession.
Test. Is that not the same situation as here?
Your Honor, it's a totality of the circumstances test. Although it's not necessary that the officers inform her that she has the right to refuse consent, it's one factor to be considered in examining the entire situation. And here that's the only fact that we have. And so the prosecution hasn't sustained its burden of showing that it's more likely than not that she gave consent.
The criminal practice track also is focused on pretrial criminal litigation, which likewise is where the vast majority of criminal cases are resolved. And this process, working together with seasoned prosecutors, seasoned defense attorneys, gives students the opportunity to understand what it really means to represent a client in a pretrial setting in the criminal context.
We contest that even though that this was a warrantless search of the defendant's home, it was still a constitutionally valid search because consent was given by the mother, who is a co-owner of the residence.
I would have loved to have had something like this because it really does, I think it gives students that taste of what reality will be like for them.
Every lecture that I've had in every small group has been fantastic.
I am participating in boot camp because I thought it would be a good way for me to gain some practical skills. A lot of the law school classes are very theoretical. We focus on legal theory. It's very academic, but now I'm sort of getting my feet wet and I'm learning what I may be doing in the future.
I feel like this has been some of the best education I've gotten, packed into a week.
This program is so unique and so amazing to bring in established, experienced practitioners to share their tips and tricks and secrets and, never do this and always do that. It makes a Tulane lawyer so much more than what other law schools are probably able to put out there.
The payoff for students in their own developments as lawyers and in their careers in finding jobs and being successful in those jobs is really so distinctive here. So I couldn't be more excited about what this is doing for students.